Is the
My
first
Lord, we have Mariam Idrisu, my Lord, from Nigerian Deposit Insurance Corporation, Liquidators to Polaris Bank. Yes, my Lord.
That's for the third defendant.
Yes, my Lord.
Yes, my Lord.
What's her position?
Legal officer, my Lord.
Appearances, counsel.
We profile humility to this honorable court. My name is Chikodi Okoji, my Lord.
Chikodi, I want to check.
My appearance, my Lord, is for the claimant.
Chikodi. Okay. For the claimant, any other appearance? Any other appearance? Any appearance for the first defendant, second and third defendants? Any other appearance?
The first defendant is represented, but she's not, it appears she's not saying anything.
Okay, please check your audio and unmute yourself. Check your audio and unmute yourself.
We can see Peace Ogbonna for the first defendant, but she's...
Peace Ogbonna, are you for the first defendant? Or you are for the third?
No, my Lord. Dangiri SN is for the third.
Okay, you are for the third.
Yes,
who is for the first defendant, the second and third?
First defendant appears to be represented by Peace Ogbonna.
But she's not talking.
Yes. She can't.
Maybe she has problems with her. Okay, let's take her appearance, Peace Ogbonna, because I can see her.
Yes.
I don't know the home.
For the first defendant, please mute yourself if you need to talk to someone. Who is for the second defendant? Any appearance for the second? Okay, Leonard, since you are for
the third defendant, my Lord.
Okay. Your name?
E. Oche. With E. Oche, Emmanuel Oche. For the third defendant.
Very well.
Thank you.
Apologies, my Lord.
Yes.
During the proceedings, the learned essay represented the second and third defendants.
Very well. Leonard Silk. Leonard Silk, he has a here. Leonard Silk. Yes.
That's correct.
Yes. So you are for the second and third.
Yes, second and third. Very sorry, my Lord, for the inadvertent.
Very well. So here is the judgment of the court.
It
is the claimant's case that she was employed by the then Reliance Bank Limited. Please mute yourself because I can hear the voice of a car. Mute yourself while the judgment is being delivered, please. It is the claimant's case that she was employed by the then Reliance Bank Limited, which through different system of corporate restructuring. Corporate restructuring by merger with other banks became Sky Bank PLC, that is the second defendant, and which later got renamed as Polaris Bank Limited, the first defendant as a Bridge Bank. Through the intervention of the Central Bank of Nigeria, she rose through the ranks to become the business development manager of Abuja main branch of the defendant through her employment with the bank until the instant dispute. She has never been issued a query, nor has she ever been cited for any misconduct or dereliction of duty by the defendant. She averred that her employment was terminated v. the photocopy of a letter of termination dated 20th of March 2018 on an alleged ground of gross misconduct, but which content it alludes more to issues of dismissal than termination. She averred that in January 2017, she invested her personal money into an online multi-level marketing investment called Swiss Golden Multi-Level Investment, which offers purchase of proportions of gold bars, which was never carried out in the name nor in any of the business premises, just a minute, nor in any of the business premises of the defendant. She continued that as an online investment platform, so many participants get referrals and investment teams online, and which investment was doing well until one Miss Happiness Chitachi Nwabubu defaulted in remitting the investment of some of the investors, including the claimants, as a result of which one of the said investors, one Miss Peace Obiora, sent a complaint to the defendant against the said Miss Happiness, who was also an employee of the bank, urging the defendant to mandate Ms. Nwabubu to return her investment. The defendant, in response, denied involvement or liability, stating that the dealing between Ms. Obiora and the named employee was in their personal capacity. She also stated that no allegation of wrongdoing was made against her by any person, nor was there any aggrieved complaint made against her, and that the disciplinary committee never confronted her with any complaint to enable her answer to any allegation made. She continued further that it was the chief compliance officer, one Mr. Kyle Diabiru, a blood relation of the bank CEO, who set the disciplinary action in motion against her for engaging in Ponzi scheme owing to a long-standing ethnic differences between the claimant and the said Kyle Diabiru. She further averred that the original chairman of the committee, one Femi Aribalui, was relieved of his seat as the chairman, and the said Kyle Diabiru took over from him, particularly in respect of the claimant's case alone. It is part of her assertion. The investigation revealed a number of other officers of the bank, including managers, who participated in the said scheme and platform, out of which only the claimant and one Onosode Ejeri, who was later reprimanded for obvious ethnic ties with the GMD, and his brother were made to face trial, while nothing was done as regards others. She averred further that the proceedings of the committee was conducted in a manner which offended the principle of fair hearing and natural justice, as the claimant was not allowed to give detailed explanation before the committee. Someone will need to, I'm hearing someone talk. Please, if you are using Infinix HOT 5, Galaxy 9, please mute yourself. We're interrupting the court proceeding. As well as Galaxy S9, please mute yourself. Infinix HOT 5, mute yourself, please. She contended that the said investment, which is not a Ponzi scheme, as alleged by the defendant, is not a civil wrong or an offense under any extant law in Nigeria. Neither did the defendant's policy forbid officers' involvement in such multi-level marketing investment. She stated further that the proceedings of the committee under the headship of Kyle Diabiru, who instigated the allegation against her, and her subsequent dismissal on the directive of the GMD/CEO, a younger brother to the chairman of the committee, all offend the principle of natural justice. She continued that the bank policy of the defendant was only amended 5 days after the claimant appeared before the disciplinary committee in order to punish her in retrospect. It was only 5 months after the claimant had appeared before the committee that the defendant published an email circular to his staff forbidding involvement in Ponzi schemes, and which punishment is dismissal. She therefore contended that her purported dismissal was based on the amended bank policy dated 29th of November 2017 that was never in existence at the time of the disciplinary proceedings. She further contended that her wrongful dismissal on unjustifiable ground of purported finding of culpability of gross misconduct based on the disciplinary proceeding bereft of the principles of natural justice. She stated that her nature of employment with the defendants entitled her to 1 month notice or salary in lieu of notice, which shall be paid contemporaneously prior to termination. She continued that the defendant only paid her 1 month salary in lieu of notice after about 3 weeks after the termination of her employment. It is part of her averment that but for her unjustifiable dismissal, she will have been entitled to 50% of her annual wages and allowance if her employment had been terminated or allowed to resign. Claimant, as a result of her wrongful dismissal, wrote a letter to the first and second defendants to reconsider their stance and which they have failed to do. It is against this backdrop that she took out a general form of complaint in this court against the defendants on the 12th of March 2019 and amended same pursuant to the order of court made on the 24th of January 2020, praying to the court for the following relief. 1, a declaration that the dismissal of the claimant from the service of the first and second defendants bank as contained in the first and second defendant letter of March 20, 2018 is wrongful, unlawful, unconstitutional, null and void, and of no effect whatsoever. 2, a declaration that the proceedings and decision of the first and second defendants bank disciplinary committee, which culminated in the dismissal of the claimant, is contrary to the principle of natural justice and a deliberate and calculated infraction of the claimant's fundamental right to fair hearing as contained in and protected under Section 36 of the Constitution of Federal Republic of Nigeria, 1999, as amended an article of the African Charter on Human and People's Rights Ratification and Enforcement Act, Cap 89 Laws of Federation 2004, and therefore null and void and of no effect whatsoever. 3, a declaration that the allegation isolated trial, proceedings and decision of the first and second defendants bank and their disciplinary committee against the claimant for obvious ethnic reasons, which culminated in the discrimination protected under Section 42 of the Constitution of Federal Republic of Nigeria, 1999, as amended on Article 28 of the African Charter on Human and People's Rights, Ratification and Enforcement Act, Cap A9, Laws of Federation 2004, and therefore null and void and of no effect whatsoever. 4, an order mandating the defendants to pay to the claimant the sum of 100 million naira as damages for breach of claimant's fundamental rights. 5, an order mandating the defendants to pay to the claimant her full salaries, entitlements, allowances, and or benefit from the date of a wrongful dismissal up to the date of judgment. 6, an order of court setting aside the decision of the first and second defendants bank disciplinary committee and the first and second defendants bank letter of termination of appointment dated March 20, 2018 for unjustifiably adjudging the claimant as culpable of allegations of gross misconduct, breach of bank's operational procedure, and unethical involvement in Ponzi scheme capable of causing reputational damage to the claimant without fair hearing. And 7, 10% interest per annum on the judgment sum till final liquidation. The first defendant in response filed a notice of preliminary objection dated 13th May 2019, praying the court on the following. First, that the suit is settled that. 2, that this honorable court has no jurisdiction to entertain the claim against the defendant, and 3, that there is no cause of action against the defendant. The ground upon which the application was brought are: 1, the suit was filed on the 15th March 2019, 11 months, 23 days after the claimant's employment was terminated, contrary to Section 2A of the Public Officers Protection Act, which provides that no proceeding can be sustained against any person for acts done pursuant to a public duty unless it is commenced with 3 months left after the act. 2, the defendant is wholly owned by the Nigerian Deposit Insurance Company and Central Bank of Nigeria, which are federal government of Nigeria statutorily established institutions. 3, by virtue of paragraph G of the 7th schedule of Section 318 of the Constitution of Federal Republic of Nigeria, the defendant constitutes a part of the public service of the Federation and it constitutes a public duty. 4, by virtue of clause 2J of the purchase and assumption agreement between the defendant and Nigeria Deposit Insurance Corporation, NDIC, the defendant is exempted from litigation liabilities arising from contract of employment of Skybank PLC. And 5, the present suit is complaining of the act of the Skybank PLC in terminating the employment of these proceedings. Yes. In support of the notice of preliminary objection is a 3-paragraph affidavit. I will skip all that. I've reduced that and the written address into the body of the judgment. The claimant responded by filing an 8-paragraph counter affidavit and the written address in opposition to the notice of preliminary objection. Legal counsel on behalf of the claimant formulated a solicitude for determination in the written address. I have also reduced that into the body of the judgment. The second and third defendants, on the other hand, filed their joint statement of defense. The first defendant equally filed, and all of that, the summary of which have been reduced into the body of the judgment. Just a minute. On the 1st of December 2020, the court granted parties in this suit leave to argue their cases on record pursuant to Order 38, Rule 33 of the Rules of this Court 2017. The purport of these rules is that parties at the close of pleadings agree to a trial where they rely on the documents and exhibit front-loaded and thereby dispense with the need for oral testimony and or cross-examination. To this end, claimant filed her written address first. The defendants equally filed their respective written addresses, and I've reduced all that into the body of the judgment. I will now go straight to the decision of the court. I've in-depthly read through the originating processes and the accompanying documents, the notice of preliminary objection, counter affidavit, statement of defense, together with all other accompanying documents and the final written addresses of parties. It is deducible from the facts and circumstances of this case, as well as issues formulated by parties, that 2 germane issues will be appropriate to determine this suit. And they are: 1, whether the suit of the claimant against the defendants is competent before this court, and if this is answered in the affirmative, 2, whether the claimant has proven her case to entitle her to the relief sought. In respect of issue 1, it is a threshold issue of jurisdiction raised by the first defendant in its notice of preliminary objection. Jurisdiction, the law is right, is the bedrock of all actions before the court. The question of jurisdiction of the court is radical and crucial, is a crucial question of competence of the court. It is the key to a door, as the blood that runs to a human body without which man cannot live. A court without jurisdiction is a court without competence or vials to sit or adjudicate on the case. The law is thus common that a court who entertains a matter without the vials has gone on its own frolic, and anything done in the whole proceedings will be rendered void. A nullity ab initio, no matter how well conducted and brilliantly decided. A defect in competence is extrinsic to the entire process of adjudication. Jurisdiction of a court is therefore considered to be the nerve center of adjudication and the live wire of all actions in court. See the case of Kuili versus Yilbok and other citation is provided. The case of Ononipo and another versus Okike citation is equally provided. The case of Palm and others versus ABU and other citation is provided. This is why it is important and inherently appropriate for a court to first deal with the issue which challenges its jurisdiction in a matter before it proceeds in an action to consider the merits of the case. See the case of Galadima and Tambai and other citation is provided. The case of Gumau versus Dahiru and other citation is provided, and the case of Pali and Ibrahim and other citation is also provided. It is the contention of a learned counsel on behalf of the claimant in the written address in support of the counter affidavit in opposition to the defendant's objection that none of the two exhibits attached to the first defendant's application as exhibits are certified as required by the Evidence Act 2011, and so the court is not allowed to look at such. In the case of Chrysler PLC versus Major Kodumi, citation is provided. The court held that where the competence of documents filed together with an application is under scrutiny, like in the instant case, the court must first determine the competence of the documents in question before considering the main application. Let me first address the later contention before addressing the main issue. Exhibit A is a photocopy of the address of the governor of the Central Bank of Nigeria, while Exhibit B is a photocopy of a certified true copy. It is true that both are public documents under the law. However, it is not true that public documents attached to affidavits need to be certified. In the case of Jukok International Limited versus Diamond Bank PLC, citation is stated here, the court held, among other things, that copies of public documents attached to an affidavit as exhibit need not be certified true copies because the documents already form a part of the evidence adduced by the deponent before the court. The documents attached to an affidavit are already exhibit before the court as they form part of the affidavit evidence which the court is entitled to look at, especially where the contents are not contested once the court is satisfied of its credibility. See also the case of DGDCIN and another versus Dinwabo and others, citation is provided. The case of BAT, Nigeria Limited versus International Tobacco Company PLC, citation is provided. The court in the case of Jukok International Limited and Diamond Bank Supra held further that copies of such documents need not be certified true copies where the content of the documents are not in dispute or challenge as in the contents not being disowned by the party contending so. Claimant did not controvert or challenge the content of the two exhibits. Again, it is tried that documents attached to affidavits in interlocutory applications cannot be objected to as the question of the admissibility of such documents does not arise at that stage. See the case of Adejuma and Governor of Lagos State, citation is provided, and the case of Olutayo and Federal University of Technology, Mina, citation is also provided, and the case of Ayabam versus COP Benue State, citation is equally provided. It is in the light of the above that I find that exhibits A and B attached to the affidavit require no certification. Next is the first leg of the objection by the first defendant, which is as regards the protection offered public officers by Section 3 of the Public Officers Protection Act, also known as POPA. It is the contention of the first defendant that the claimant, having filed the action after a 3-month period, has no competent action against the first defendant, which is a public officer. Pertinent question to ask at this stage is who is a public officer who enjoys the protection of POPA? It is the contention of the first defendant that it is the creation of the Central Bank of Nigeria in conjunction with the third defendant, and as such, it enjoys protection under the Act, going by the provisions of Section 318, 7th Schedule to the Constitution of Nigeria 1999 as altered. In answering that question, I have alluded my mind to the provision of Section 318 Supra and Section 19 of the Interpretation Act, which defines a public officer as any person holding any public office of the Federation in any of the capacities enumerated therein, which includes staff of any company or enterprise in which the government of the Federation or its agencies holds controlling shares or interests. See the definition given by Nikki Toby GSC of blessed memory in the case of AG Lagos and Eco Hotels Limited, and another citation is provided. A public officer is therefore any person holding public office in the performance of public duty with duties imposed by law. It is not in dispute in this case that both the CBN and the third defendant are both agencies of the federal government. The contention of the claimant seems to be that there is nothing on record like the certificate of incorporation to prove their ownership of the first defendant. The claimant in the counter affidavit and written address in support contended that the first defendant is not a public officer and that the CBN and NDIC are not the owners of the first defendant, as the certificates of incorporation are not before this court, as stated earlier, and that the first defendant as seen in Exhibit B is a private limited liability company. One must first ask, what is the status of Polaris Bank, that is the first defendant? I peruse the contents of Exhibit A, and I find in there that the first defendant was established as a bridge bank, as admitted by the claimant in their statement of fact, by the joint effort of the third defendant and CBN after the failure of the second defendant in pursuance of their statutory duty. I've equally perused Exhibit B, and I find in the commencement/introductory part that though the first defendant was referred to as a private limited liability company as contended by counsel on behalf of the claimant, it is equally clear from that clause that it was incorporated pursuant to Section 39(1) of the NDIC Act, number 16 of 2006. A perusal of the said section clearly shows that the first defendant is a creation of circumstance by the intervention of the third defendant and the CBN in the banking sector, and which is controlled by the third defendant. NDIC is a provisional liquidator to the first defendant, but can it be said that the third defendant has ownership of the first defendant, which is a private limited liability company? The Supreme Court in the case of Okomo Oil Palm Limited and Isehenge citation is provided held those, and I quote, besides having a controlling numbers of shares in a company is not synonymous with its ownership once it is incorporated as an entity of its own and having its own separate legal existence. Whatever impression was therefore given in this case that the Federal Civil Service Commission sat in the background and maintained a direct or remote control over the activities of the appellant by applying thereto its rules, a corporate entity with its own legal existence must be rejected as a wrong and ill-conceived legal proposition, unquote. As posited by the Apex Court in the above case, having controlling shares in a company created with its own legal existence does not equate to ownership. The first defendant is a separate corporate legal entity with its own legal existence, and as such cannot be said to be owned by the third defendant, even though it incorporated and appointed the management staff and regulates the affairs of the first defendant. At best, it can be said that the first defendant is a subsidiary of the third defendant or that the third defendant is the promoter of the first defendant. The Court of Appeal in the case of FBIR versus Integrated Data Services Limited citation is provided, had this to say as regards whether subsidiaries of public corporations can be regarded as public officers, and I quote, if the cross-appellant is a limited liability company, can he claim to be a public officer? It has been settled that there is a difference in the legal status of a public corporation and its subsidiaries. While a public corporation can claim to be a public officer, its subsidiaries, especially limited liability companies, cannot claim to be public officers. The legal status of a public corporation and those of a limited liability company registered under CAMA makes them distinct legal entities. They quoted the case of Okomo Oil and also the case of Aso Motel Kaduna Limited versus DMO, unquote. The first defendant is a separate legal entity, private legal limited liability company, which cannot be said to be engaged in the execution of public duties, thus cannot be ascribed the same status as that of public corporation, staff of NDIC or CBN, which are obviously public officers, as it has its corporate existence. Counsel on behalf of the first defendant cited an incomplete authority on this point, that since the CBN and NDIC have controlling shares in the first defendant is a public officer. I've taken my time to get the said authority through those cited incomplete. I've read the authority referred to the case of Matthew Oluwole and PHCN citation, suit number CA/IL/36/2010, delivered on 26th day of April 2012. I'm of the view that the decision in that case is inapplicable and distinguishable from this case, because unlike sections 2 and 9 of the Electric Power Sector Reform Act, Cap P41 Laws of Federation 2004 considered in that case Section 39 of the NDIC Act, which empowers the NDIC to establish a bridge bank, as in Polaris Bank in this case, did not provide that the NDIC or the CBN will have any controlling shares in the bridge bank. In fact, Section 39, subsection 3 of NDIC Act provides that the provisions of paid up or issued capital shall not apply to the bridge bank. Again, in that case, the assets and liabilities of PHC and PLC were still controlled by the organs of the federal government. However, the reverse is the case in this situation. There is nothing in Section 39 of NDIC Act that says that the assets and liabilities of the bridge bank shall be controlled by NDIC. The bridge bank, Polaris, assumes the deposits and liabilities of a failing or failed bank. In fact, Section 39, subsection 1 of the Act, that is NDIC Act, provides that the bridge bank shall purchase the assets of a failing bank. So this case is clearly distinguishable from the case of Matthew Oluwole and PAC and Supra. As such, the decision of the same Court of Appeal in FBIR versus Integrated Data Services Supra, relying on the Supreme Court decision in the case of Okomo Oil Palm Limited and the Shehehe Supra, is more applicable to this present case. In the line of the decided cases, I am of the firm view that the first defendant is not a public office and its staff are not public officers under the law, and as such cannot enjoy the protection afforded public officers under POPA. I so find an oath. I am also of the candid opinion that even if the first defendant were a public officer protected by law, the case of the claimant is not cut off by the period of limitation under POPA. The counsel for the first defendant in his written address had cited the case of NPC versus Williams Supra in support of his assertion that the provisions of POPA applies to contract of employment. I'm afraid that is not the current position of the law. In the recent case of CL Risk and Asset Management Limited and the Ekiti State Government, citation is provided, the Supreme Court held inter alia that the protection afforded public officers under Section 3 of POPA does not apply to cases founded on contract or breach of contract. See also the case of National Revenue, Mobilization, Allocation, and Fiscal Commission and others, Zajibola Johnson and others, citation is provided. And the case of Bob Manuel and AG River State, citation is equally provided. The case of the claimant having been founded on contract cannot be cut off by the period of limitation, Section 3 of POPA. Ditto claims for accrued entitlements. It is in the light of all the above reasons that I find that the case of the claimant is not defeated by Section 3 of POPA. I so hold. The second leg of the objection is that the claimant has no cause of action against the first defendant, as the first defendant is absolved of any liability on litigation on contract of employment with a failed bank. The defendant relied on certain clause 2J of Exhibit B. I've perused the whole of the said Exhibit B, and it is interesting to note that the document exhibited is not fully paginated. Page 4 is missing in the said document and a number of all other pages. It is equally evident that the commencement of clause 2 that the defendant is relying on to object to the jurisdiction of this court is missing. All the court can see from the said exhibit on numbered page is a list of items from D to K. Where is the commencement and items A to C, if I may ask? The implication of this is that some parts of the agreement are withheld and are not reflected in Exhibit B. I agree with the claimant's counsel who argued that the document must be interpreted as a whole. A court in deciding a matter must be reluctant to rely on an incomplete or withheld evidence. See the case of Igbo and FRN citation. FRN citation is provided. This raises some questions. What is in those portions or pages of Exhibit B that are missing or probably withheld? Why are those pages missing or withheld? The correct position of the law on missing pages of a document tendered as one indivisible document is that it is the duty of a party tendering it to offer a plausible explanation on the availability, failure of which such document would not be attached any probative value as regards its content. So the case of Harder Trading Manufacturing Limited and another versus Trop, citation is provided. The first defendant did not give any credible explanation for the missing pages and parts of the said Exhibit B. There is nothing else to say than the documents being incomplete cannot be utilized by this court for the purpose of determining the exclusion of liability of the first defendant and has to be discountenanced. The document is therefore worthless and unworthy of ascribing any probative value. It is thus discountenanced. There is no other document in proof of the objection of first defendant of its immunity to litigation on employment contract before the court. It is in my calm view that even if the said document were to be complete, the first defendant is excluded from liability arising from employment contract with the failed Sky Bank in it. It would be the most unfair and unjust thing for this court to do. Exhibit A, annexed to the affidavit in support of the objection, particularly paragraph 5 in the said document, clearly states that Polaris Bank assumes the assets and liabilities of the failed Sky Bank. It is most unfair for Exhibit B to now seek to exclude liabilities arising from employment contract when the first defendant has already assumed assets of the Sky Bank. More so, where the bank is already wound up and already under liquidation by NDIC. Who then will an employee of Sky Bank with a genuine claim proceed against? This will force a situation of helplessness on the employees or former employees with genuine claims. This is an attempt to shut workers out of their rights and will be the most unfair labor practice and will be against international best practices to so do. This court is a court of law and court of equity. It will be most inequitable and unlawful to sustain this objection. The second leg of the objection is equally discountenanced, consequent upon which, upon the foregoing, this court finds no merit in the preliminary objection raised by the first defendant. The notice of preliminary objection filed by the first defendant is hereby dismissed for lacking in merit. Equally, in respect of issue 1, the second and third defendants, viz. Their statement of defense contended that the claimant did not obtain the leave of the Federal High Court under sections 417 and 425(1) of CAMA. Learned counsel on their behalf equally raised this issue in the final written address. I've already addressed the issue of leave in the ruling earlier delivered in this case. However, counsel in the final written address cited a new case which was not in the written address in support of motion in respect of which the third reading was delivered. Counsel cited the Supreme Court decision delivered in 2014, that is the case of Re Amolegbe Supra, wherein the court addressed the issue of sanctions of the court or committee and committee of inspection. I've read the decision in the said case, and I can say that the facts of the case is somewhat different from the case at hand. The application to join NDIC in that case was made before the Supreme Court. In the instant case, the claimant made the application, which was granted, after which the first defendant filed a motion on notice to object on the ground of jurisdiction together with a statement of defense and accompanying documents. According to the decision of the court in Re Amolegbe Supra, the sanction of court or of committee in inspection ought to be obtained by a provisional liquidator, either NDIC, before it brings or defend an action in the name of the affected company. Learned counsel submitted that the condition precedent was not complied with by the claimant. While it is true that a sanction ought to be obtained before NDIC can bring or defend an action on behalf of Sky Bank, it is not true, as posited by the second and third defendants and learned counsel, that it is in the claimant that should obtain the sanction of court, that it is the claimant that should obtain the sanction of court. Sanction of court in respect of provisional liquidator in section 425 of CAMA is different from leave of court required in section 417 of CAMA. The liquidator itself is the one to obtain the sanction of the court and not the other way around. The court in Re Amolegbe Supra was clear when it held thus, I quote, in other words, where no such sanction of either the court or committee of inspection is sought and obtained by the liquidator, no legal action or proceedings can be brought or defended by the liquidator. The application herein did not produce any evidence to show that the provisional liquidator has obtained such sanction of the court or of committee of inspection to bring or defend any action or other legal proceedings in the first respondent, unquote. From the foregoing, it is clear that sanction in respect of a liquidator bringing or defending an action must be obtained by the liquidator itself. While it is true that the claimant is the one to obtain the leave of court to sue second defendant as provided under section 417 of CAMA, is however not the one to obtain the sanction of court requested under section 425 of CAMA. Be that as it may, the issue of leave or sanction of court not being had and obtained first is a question that borders on procedural jurisdiction of this court and not on the substantive jurisdiction of this court to entertain this suit. This court is clothed with the exclusive jurisdiction to entertain cases of employment contract by virtue of section 254C of the Constitution of the Federal Republic of Nigeria 1999 as amended. The exclusivity of the jurisdiction of this court to entertain cases bordering on employment, as in the instant case, has been given judicial recognition or seat, if you can use that word. In the case of Skybank versus EU, citation is provided. The powers of this court to entertain this case cannot be limited as it is constitutional. More so, the right of a person to access the court to seek redress is a constitutional right which cannot be denied by this court. I've already ruled on this issue on the 12th of November 2020. I therefore adopt my ruling and again hold that this action is competent against the second and third defendants. It is in the light of the foregoing and the earlier reasons given that I find that this court has the power to entertain the case of the claimant as presently constituted. I hereby resolve the first question in the affirmative and in favor of the claimant, I so hold. Now let's go to issue 2 as regards the merit of the case at hand. The claimant's claim is founded on contract of employment. It is tried that there are basically 3 categories of contract of employment, namely master-servant relationship, servants who hold their office at the pleasure of their master, and employment with statutory flavor. See the notorious case of Lunge versus FBN PLC on this subject. It is not an issue that the relationship between the claimant and her employer, second defendant, was that of a master-servant relationship. It is equally not an issue that the employment of the claimant has been terminated by the second defendant before it came under liquidation of the third defendant. The claimant in this suit is seeking the grant of declaratory leave. It has been held in plethora of judicial authorities that in a claim for declaratory leave, as in the instant case, the claimant must proceed on the strength of her own case and not on the weakness of the defendant's case. The claimant will not be entitled to judgment even on admission of the defendants. It is the duty of the claimant to first prove the existence or non-existence of what he or she asserts by relevant, admissible, and credible evidence. Once this burden so placed on the claimant is discharged, the onus then shifts to the defendants. See the case of Uzodima and Ihedioha. Citation is provided. The case of Ehile versus Ikorodu local government. Citation is provided. However, a claimant is allowed to rely on aspects of defendant's case that support his own. See the case of Hanatu versus Amadi. Citation is provided. The case of Salisu and Mobolaji. Citation is provided. And the case of CDC Nigeria Limited and SCOA. Citation is equally provided. It is the claimant's claim that she was in the employment of a second defendant, which is now under liquidation by the third defendant. The first defendant contended in its pleadings that the claimant has no cause of action against it. I've already addressed this contention of the first defendant earlier in the judgment under the notice of preliminary objection. However, counsel on behalf of the first defendant in his final written address raised the question of the separate legal entities of the first and second defendant, which I feel the need to address. Counsel relied on the case of New Nigerian Newspapers versus Agbomabini Supra and submitted that the first defendant cannot be made to bear the second defendant's liability because the second defendant still has a separate legal personality, irrespective of the fact that its assets and liabilities have been taken over. I agree with the position of the law that a company does not lose its legal personality by liquidation until it is fully wound up. However, that does not translate to the fact that the company which took over its assets and liabilities cannot be proceeded against where the need arises. The first and second defendants have separate legal personality, but the first defendant cannot be absolved of liability or from bearing consequences of the actions of the second defendant, since it was the first defendant who took over the assets and liabilities of the second defendant, as I've held supra. The second and third defendants also contended in their joint statement of defense that the claimant has no cause of action against them, as the claimant is an employee of the first defendant. The claimant, in proof of her assertion, pleaded and tendered her employment letter, her staff placement in the second defendant, and her letter of termination of appointment. I perused the said exhibits, and I find that the claimant was actually in the employment of the second defendant and was the same person that terminated the claimant's employment. The second defendant, which employed the claimant, though under liquidation, still has a separate legal entity until finally wound up. So the case of New Nigeria newspaper and Agbo Mabini Supra. It then means it can still sue and be sued in its name. It is not immune from legal action. There is nothing in the law that says it cannot be sued. In the same vein, Section 425(1)(a) of CAMA provides that the liquidator in winding up by the court shall have the power to bring or defend any action or legal proceedings in the name of the company being wound up. By the provisions of Section 40 of NDIC Act, Supra, the third defendant is the liquidator of the second defendant, as I've stated earlier, who shall be deemed to have been appointed by the order of Federal High Court in winding up. The second and third defendants in this case equally admit that the second defendant is under liquidation by the third defendant. It is tried that facts admitted need no further proof. See the case of Al-Hassan and another versus Ishaku and others, citation provided. By the combined effect of Section 40, subsection 1 of NDIC Act and Section 4171 of CAMA, this action can be maintained against the third defendant being the liquidator of the second defendant. I therefore find that the claimant has a justifiable cause of action against the second and third defendants. It is the claimant's claim that what she was alleged to have done is not in conflict with any known policy of the second defendant. Claimant maintained that engaging in the kind of investment platform she was engaged in was not contrary to the second defendant's policy. She asserted that the second defendant's policy was only changed after she had been alleged of getting involved in a Ponzi scheme and given invitation to appear before the panel, and precisely 5 days after her appearance before the committee. The meat of her case is that she was unjustly dismissed by the second defendant. The law is right that an employment can be said to have been wrongfully determined if it was done in contravention of the terms and conditions regulating the contract of service, or differently put, was terminated in a manner not contemplated by the stipulations in the condition of service. So the case of Union Bank PLC versus Salahuddin, citation is provided. The case of Union Bank of Nigeria PLC versus Chinyere, citation is also provided. The claimant, in proof of her case, pleaded and relied on an amended policy, the old policy cover and a cover email of 29th of November 2017. I've gone through all the documents tendered by the claimant in this case, and I cannot find any amended policy of November 29th, 2017, or any old policy, as the claimant would want this court to believe existed. All I can find is a document in the name of the first defendant, Polaris Bank, titled Staff Policy on Recruitment, which was not pleaded or tendered by the claimant in relation to the above assertion. I've equally gone through the said email of 29th November 2017, and I must say there is nothing in it to show that the amendment made was in respect of staff involvement in Ponzi scheme. The said email only notified staff of an amendment of a disciplinary policy and did not state what the amendment was. The only thing that could show What the amendment was is the old and new policy, which the claimant did not place before this court. The only policy that I find tendered by the claimant before this court is a staff policy on recruitment, which cannot by any stretch of imagination be the same with the disciplinary policy as seen in the email. One would have expected that the claimant who pleaded and relied on both the amended and old banking policy documents of the second defendant in support of a stance would do well to tender both documents before this court, from which the court can establish a claim of not being in contravention of a bank policy as at the time of her involvement. I'm aware of the position of the law that states that it is not compulsory to tender in evidence document pleaded. See the case of Bang Bade Me and others versus Oriari citation is provided. However, where the claimant bases her claims of having not contravened the provision of a bank's policy by involving in the investment scheme on the said document, she should have tendered them in evidence. I'm equally aware of a subpoena. Sorry, I'm equally aware a subpoena was issued at the instance of the claimant compelling the second defendant to produce copies of the two policies. The said subpoena dated 30th of November 2020 was issued at the instance of the claimant. The court in the case of Umar and the state citation is provided, held that it is not the business of the court to ascertain if a subpoena has been obeyed, except where it was issued so motu by the court. It is the business and duty of a party at whose instance the subpoena was issued to bring to the notice of the court that the person subpoenaed has been served and is deliberately disobeying the order of court, and as a result of which the party can either move the court to compel the obedience of the subpoena or that sanctions should be visited on the contemnor. So the case of CPC and INEX citation is provided. After the issuance of a subpoena in the instant suit, the court sat on the 1st of December 2020, and the claimant counsel was in attendance, during which parties adopted the argument on record procedure. Regrettably, the claimant counsel did little or nothing towards the implementation of the subpoena. Counsel did not inform the court about the implementation and compliance with the subpoena by and it was deliberately disobeying the court. It is not the duty of the court to descend to the arena and do what a party is supposed to do. Sorry, I think it's the recording. I was a bit taken off, so I would continue from there. After the issuance of the subpoena in the instant suit, the court sat on the 1st of December 2020, and the claimant counsel was in attendance, during which parties adopted. The claimant counsel did little or nothing towards the implementation of the subpoena. Learned counsel did not inform the court about the implementation and compliance with the subpoena by the second defendant who was subpoenaed. There is nothing before the court to show that the party subpoena has been duly served and it was deliberately disobeying the court. It is not the duty of the court to descend to the arena and do what a party is supposed to do. So the case of Umar and the state Supra. Interestingly, counsel to the claimant in his final written address while listing documents relied on and tendered by the claimant on pages 14 to 15 did not list any of the two policies which claimant based her assertions on. Where the claimant has acted rightly as regards compliance with the subpoena and the party subpoena still fails, the claimant can take advantage of Section 167D of the Evidence Act 2011 on withholding evidence. However, where the claimant has herself failed in her duties, the provision of Section 169 would not avail her. The claimant equally pleaded that it was only on the 16th of March that the second defendant first notified his staff about Ponzi scheme vid email. The first defendant, on the other hand, contended that the said email was a form of sensitization on an already existing policy which by banking custom is known to all members of staff. I perused the document tendered in proof of this. I find that there is nothing in it to show that it was a new notification. In fact, I find on the face of the said document that the email was in 3 pages. However, it is only the first page that the claimant made available to this court. A claimant who would want this court to believe that she was not in contravention of a bank policy, as at the time of her involvement, has done little or nothing in establishing this claim. She failed to canvass evidence in support of her claim. This, I must say, is fatal to her case. I still find and hold. The defendant, on the other hand, contended that what the claimant did was contrary to the bank's policy, as a result of which it pleaded and relied on disciplinary policy and sanctions grid of the bank. I've taken a look at the document pleaded, which is before this court, and I find that it is a document in the name of Skybank titled Disciplinary Policy and Sanctions Grid. The claimant in her reply did not challenge the existence and content of the said Skybank PLC and sanction grid, which was relied on by the first defendant, which would mean she has joined issues with the defendant on the said document. In fact, she did not make any reference to the said document in paragraph 12 of her reply. We should have addressed that as against what she did in paragraph 9 with letter of dismissal of happiness in Wabagu. It is a case of a claimant by her release 1, 2, and 3 taken together that her trial before the Staff Disciplinary Committee is bereft of the principles of natural justice and the breach of her fundamental rights to fair hearing. As such, the termination of her employment is wrongful. In the recent case of Eze and unit judge citation is provided, the Supreme Court held that the standard of fair hearing requires the observance of the twin pillars of rules of natural justice, namely, aude autorem partem, hear the other side, and nemo judes in casu sua, no one should be a judge in his own cause, the rule against bias. It is a well-settled principle of law that it is the duty of a party alleging the breach of right to fair hearing to prove the breach, and such must be done in circumstances of the facts of the case. See the case of Iloka and another versus Enemoa and others. It is claimant's claim that the chairmanship of Kyle Diabiru on the disciplinary committee that recommended her termination amounted to being a judge in his own cause, as the said Kayode was the one who instigated and influenced the allegations of gross misconduct against her through his younger brother, the GMD CEO of the second defendant. The first defendant joined issues with the claimant on these claims and contended that it was the unethical conduct of the claimant that caused her disciplinary procedure, and the said Mr. Kayode Abiru had no personal business or grievance or any prior infraction with the claimant and was not an interested party to be a judge in his own case. It is well settled that it is the duty of he who asserts to prove. See the case of Sharing Cross Education and Services Limited and Maru, citation is provided. The case of Maihaja versus Gaydam, citation is provided. It is equally tried that facts pleaded are not evidence and not a substitute for evidence. Facts pleaded are to be proved by credible evidence. Any facts not supported with evidence are valueless and will be deemed abandoned. See the case of Boniface, Anyika and Company, Lagos Nigeria Limited versus Zo, citation is provided. The case of Ben versus Nigeria Social Insurance Trust Fund, citation is equally provided. Claimant did not need any evidence in proof of her assertion that the said Kayode Abiru instigated or had anything to do with the allegations leveled against her, which will have meant that he is a tainted person and whose chairmanship of the committee will have been in breach of her right to fair hearing. Failure of the claimant to lead evidence as such is fatal to her case. The claimant equally did not in any way or anywhere in her pleadings plead that she objected to the chairmanship of the said Kayode Abiru on the ground of her right to fair hearing, since she claimed he does not like her for obvious ethnic differences. Claimant did not raise the issue of the chairmanship of the said Abiru before the panel. The assertions of the claimant that the chairmanship of Kayode Abiru amounts to being a judge in his own case, in breach of the principle of natural justice, are therefore discountenanced as they are unfounded and unproven. I so hold. It is equally part of the claimant's claim that the said Kayode Bill was made chairman of the committee especially for her. I'm afraid there is nothing before this court to lend credence to this allegation of the claimant. In fact, the claimant herself, read paragraphs 21 and 22 of her amended statement of facts, alluded to the fact that she was not the only one who appeared before the said committee under the chairmanship of the said Kayode Bill. According to claimant, one Omosode Ejere, a manager just like herself, equally appeared together with her before the same committee headed by the same Kayode Bill. It is in my respectful view that the allegation of the claimant that Kayode Bill was made the chairman of the said committee especially because of her, in order to bring her to judgment, is unfounded, cannot be believed by this court. I so find and hold. The claimant also alleged the proceedings of the committee amount to an infraction of the principle of natural justice, as the said Kayode Bill, the chairman of the committee, showed obvious signs of bias and ethnic discrimination before and during the proceeding. Claimant had alleged that she was discriminated against because she came from a different ethnicity from the chairman of the committee and his younger brother, the CEO GMD. She alleged that one Omosede Ejere, who was tried just like herself on the same ground, was merely reprimanded because she came from the same ethnicity with the chairman of the committee and the CEO GMD. The first defendant in his statement of defense contended that the Sky Bank PLC, in line with international best practices, frowns at any form of sexual, tribal, or religious discrimination. Claimant, who wants the court to believe that she was discriminated against on ground of ethnicity, has not placed any evidence before the court that she was discriminated against as claimed. There is generally no duty on the defendant to prove the negative. There is generally no duty on the defendant to prove the negative. However, the claimant will only be discharged of this burden, and same will move to the defendant when the claimant has proven his or her claims by credible and cogent evidence. See the case of Union Bank versus Ravi Abdul and Company Limited, citation is provided. The case of Marine Global Services Limited and Southern Ijaw Local Government Council, citation is provided. Claimant failed to discharge the burden on her to prove by credible, cogent, concrete, and convincing evidence that she was really discriminated against on the ground of ethnicity, or that there was any bias on the part of the chairman as alleged, sufficient that would make the proceedings an infraction of the principle of natural justice. Claimant should have done more than mere allegation to establish this. There was no other incident or witness to corroborate her assertion. By merely alleging that the chairman discriminated against her on the basis of ethnic differences without more cannot be sufficient to prove her assertion. Therefore, failure of the claimant to substantiate her assertion is fatal to her case, same is unreliable, and thus discountenance. I so find and hold. Claimant equally contends that the proceeding of the committee was conducted in a near coerced manner without fair hearing, as she was intermittently hushed down by and never allowed to give a detailed explanation, as one Mr. Matayo mandated her to give a yes or no answer in contravention of the principle of natural justice. Claimant has the primary duty of establishing these facts before the court. There is nothing before the court in proof of this allegation of infraction of the rules of natural justice during the proceedings of the committee. It will accord with normal official relationship to expect that the activities of the committee must have been recorded to render evidence given on it acceptable. This in line with the power given the court to presume certain facts under Section 148(1) of the Evidence Act. Although there is no law which states that the minutes of meeting is the only evidence of what transpired in a meeting, it must be pointed out, however, that minutes of meeting will not be needed in proof of what transpired where parties are addendum as to what transpired. See the case of Olariwaju and Governor of Oyo State, citation is provided. The defendants in the instance should join issues with the claimant as to what really transpired at the committee sitting when the first defendant contended that the claimant was given fair hearing. So it cannot be said that parties are addendum as to what transpired during the proceedings. It is worthy of note that the first defendant tendered the minutes of the committee sitting of the 24th of November 2017 through an application dated 2nd December 2020 pursuant to the order of court, an argument on record. However, the said minute was not pleaded by the first defendant in their pleading, but facts linking the minutes to the issue at hand were pleaded. The Apex Court per Okoro GSC in the case of Sani and Kogi State House of Assembly and other citation is provided, have held that a document need not be specifically pleaded to be admissible, provided relevant facts by which the document is covered have been expressly pleaded. See also the case of Union Bank versus Moro Foye, citation is provided. The case of Allied Bank of Nigeria versus Akubweze, citation is equally provided. It is in the light of the above that I will consider the said document. I peruse the said minutes and I find that there are no specific details of what actually transpired during the appearance of the claimant before the committee. The said minutes contain general things that happened that day. In fact, there is nothing on the minute as regards the claimant except on the recommendation referred to in the minute and attached. I have equally perused the said exhibit and I find it less helpful either as regards the manner in which the trial of the claimant was conducted. I find that there is no evidence before the court in proof of the claimant's assertion that she was not given fair hearing before the committee as she was coerced. Claimant did not lead any credible evidence in support of her assertion. The claimant has not been able to substantiate her claims that she was not allowed to give sufficient explanation in defense of herself before the committee. I so hold. It is equally the claimant's grounds that of all those who took part in the investment scheme, she was the only one punished. Onosode Ejere, who appeared before the panel like herself, was merely reprimanded according to her. The first defendant joined issues with the claimant over this and contended that it was not only the claimant that was punished. Other members of staff found culpable were punished too, based on their level of involvement. The document referred to and attached to the minutes of meeting tendered by the first defendant contains the names of those who were tried before the panel. I perused the said document and I find that the claimant was not the only one recommended for punishment as proceeded by her. In fact, Omosode Ejere, whom claimant claimed was only reprimanded, was placed on 3-month suspension without pay. It is equally clear on the face of the document that Happiness Nwabugu, who was involved in the same scheme, was also recommended for punishment. In fact, on the face of the document, Happiness was recommended for discipline on 2 separate offenses, one of which is involvement in Ponzi scheme, and for which dismissal was recommended for both. I've equally considered the letter of dismissal of the said Happiness, and it is clear on the face of the letter of dismissal that the said Happiness was not dismissed in respect of the offense of involvement in Ponzi scheme, which is one of the offenses she stood trial for, as rightly claimed by the claimant, but in respect of the second offense. The principle of natural justice will only be said to have been breached where a party was not given notice of the allegation against him or her, or allowed to defend him or herself. To satisfy the principle of natural justice, the person likely to be affected by the disciplinary action is enough if the person was informed of the allegation to enable such a person make a defense. See the case of Nairobi Eke versus NELMC, citation is provided. Claimant herself alluded to the fact that she was aware of the allegations against her and for which a committee was set up and which she appeared before it to make her defense. Her only ground seems to be that she was not allowed to give sufficient explanation, which I've held earlier that she was not able to substantiate. In view of the foregoing, I find it hard to believe that the claimant was denied fair hearing before the committee as she had not been able to establish this fact. Claimant claims that her employment was brought to an end by the second defendant via the letter of termination. In support of her claim, she pleaded a photocopy of letter of termination of appointment and gave the first and second defendant notice to produce the original. In the case of a wage and OM Oil Industries Limited, citation is provided. The Apex Court held that serving notice to produce in line with Section 91 of the Evidence Act 2011 does not compel the other party to produce the said document, but rather entitles the parties serving the notice to adduce secondary evidence of the document in question. In the instant case, claimant not only pleaded the document, but also attached the photocopy of the said letter to her claim. Parties in this case adopted the argument on record procedure as stated supra. The secondary evidence of the claimant's letter of termination is before this court, and the court will accept same in proof of what it seeks to establish. I so hold. Claimant contended that the said letter, although headed as termination of appointment, is a dismissal. The first defendant, on the other hand, responded read paragraph 5, 6, and 29 of his statement of defense filed on 3rd of March 2020, that contrary to the claimant's claims, the letter was not a dismissal letter, but termination of claimant's appointment as headed. In the case of Jumbo versus PEFMD, citation is provided. The Apex Court distinguished between termination of employment and dismissal. For termination, the employee is enabled to receive terminal benefits under contract of employment, and which right is mutual. That is, it can be exercised by any of the two parties. However, dismissal, on the other hand, is punitive and, depending on the contract of service, very often entails a loss of benefits and carries an unflattering opprobrium on the employee. See also the case of FBN PLC versus Maker, citation is provided. I peruse the said letter titled Termination of Appointment and the attached document. It is tried that documents speak for themselves. The court is not concerned with the witness or parties' interpretation of it, but with the interpretation of a document through words used therein. See the case of Yadis Nigeria Limited versus GNIC, citation is provided. A perusal of the said letter dated 20th of March 2018 clearly shows that the employment of the claimant was said to be terminated with effect from 21st of March 2018. Attached to the said letter is a statement of claimant's indebtedness entitlement, and which fact was pleaded by the claimant, read paragraph 40 of her statement of fact. Equally, claimant, who had contended that the letter, though headed termination, was more of a dismissal, and upon which her release are based, is the same person who in paragraphs 39 to 41 of her pleadings is contending that she's entitled to be paid 1 month's salary in lieu of notice contemporaneously and not after 3 weeks, as was done by the second defendant. In this case, this to me is a clear case of approbating and reprobating. The claimant cannot contend that she was dismissed contrary to the letter, and at the same time be contending that by the nature of her employment, she's entitled contemporaneously payment, entitled contemporaneously for payment of 1 month's salary in lieu of notice prior to termination. It is right that a party must be consistent in the presentation of his or her case and should not appropriate and reprobate. A party is not allowed to speak from the two sides of his mouth. See the case of Awala and Nigeria Telecom, citation is provided. The case of Asaboro and Pan Ocean Oil Corporation Nigeria Limited, citation is equally provided. The case of Iweja and OM Oil Industries Limited, Supra. It is equally clear from the facts before the court, and as pleaded by the claimant herself, read paragraph 40 of the amended statement of fact, that she was actually paid the amount computed for her as 1 month's salary in lieu of notice in the document attached to the letter. In fact, claimant in her reply filed on the 9th of March 2020 to the statement of defense of the first defendant did not deny or join issues with the first defendant on the fact pleaded by the first defendant in paragraph 29 of its statement of defense filed on the 3rd of March 2020 that the claimant was not dismissed, but rather her employment was terminated, hence the 1 month salary in lieu of notice paid to her. It is right that facts not specifically challenged are deemed admitted and established. See the case of Sheshe versus Ibrahim, citation is provided. Claimant, having not disputed the facts in paragraph 29 of the first defendant's statement of defense, in her reply is an establishment of such fact. Although the termination of claimant's employment is as a result of disciplinary action, the fact that the claimant was to receive some entitlement at the end of the relationship and was actually paid 1 month's salary in lieu of notice clearly points strongly to the fact that the severance of claimant's relationship with her employer was one of termination rather than dismissal. If it was dismissal, then the claimant would not have been paid a month's salary in lieu of notice. I am of the view that the claimant's employment claimant. Sorry, this recording that is disconnecting me intermittently. Claimant in the instance suit made a whole lot of false about the breach of the rules of natural justice and fair hearing in her disciplinary proceedings. The question that is to be asked at this stage is whether the claimant can succeed in the absence of the breach of her right to fair hearing. The claimant in this case founded her case on an employment contract. It is right that in a purely master-servant relationship, as in the instant case, the employer reserves the right to terminate the employment of his employee with or without any reason at all, provided it is done in accordance with the terms of the contract of employment as stated supra. In the instant case, termination cannot be wrongful unless it is done in breach of the terms and conditions of the contract of employment. See the case of Banye and Union Bank, citation is provided. The case of Isheno versus Julius Berger, Nigeria PLC, citation is provided. The claimant in the instance suit neither pleaded nor adduced evidence of her condition of service with the second defendant. She only pleaded that the disciplinary procedure was not conducted fairly. It is part of the claimant's claim as pleaded in paragraphs 39 to 41 of her amended statement of fact that by the nature of her employment, she was entitled to 1 month's salary in lieu of notice upon termination of employment, as I've stated earlier, and where salary in lieu of notice is not contemporaneously made, such termination is invalid and amount to a nullity. The claimant in the instance suit did not place before this court the terms and conditions of employment with the second defendant, as I've stated, supra. In the case of Oforishi and Nigerian Gas Company Limited, citation is provided. It was held that it is the duty of an employee alleging wrongful termination of employment to state the provisions of the condition of service that has been breached and in what manner same was breached. In the case of University of Calabar, an SCN citation is provided. Excuse me. The court held that in an action whereby the plaintiff or claimant seeks declaration that the termination of employment was wrongful, the most fundamental issue to put before the court is the condition of service. Such an aggrieved party must aver it as a cardinal issue in the pleadings and also lead evidence in the court of non-compliance with the terms and condition of service. The court in the University of Calabar and SCN Supra went further that if the conditions of service have been pleaded, the plaintiff may now go ahead to prove that the disciplinary procedure was not conducted fairly. As I've said herein before in this judgment, the case of a claimant is entitled to fail for failure to prove her condition of service since she has not been able to equally prove the breach of her right to fair hearing. She has a duty to plead and lead evidence on both the condition of service and the breach of her rights. She cannot plead one and leave the other. Say the case of Aji and Chad Basin Development Authority, citation is provided. Interestingly, claimant herself pleaded via paragraph 40 of her amended statement of fact that she was actually paid 1 month's salary in lieu of notice, although it was paid after almost 3 weeks. The first defendant in response, via paragraphs 28 to 29 of his pleadings, confirmed the payment of 1 month's salary in lieu of notice to the claimant, but contended that the claimant had to go through the normal prescribed clearance of the second defendant, which the claimant is well aware of. Claimant neither pleaded nor led any evidence to show that she did not accept or return the said money paid to her. In the case of Imperial Medical Center and another versus Ahamefule, citation is provided. It was held that an employee who has accepted the payment of salary in lieu of notice cannot turn around to allege wrongful termination. The acceptance of payment renders termination mutual, and a estoppel by conduct will stop such an employee from claiming otherwise. See also the case of Julius Berger versus Nwebu. Citation is provided. Consequently, I find that the claimant cannot allege that the termination of employment was wrongful or a nullity, having accepted the payment of 1 month's salary in lieu of notice paid to her. In line with the above and the earlier reasons given, I find that the claimant has failed to prove that the termination of her employment was wrongful. Consequently, claimants release 1, 2, and 3 fail. I so hold. In the same vein, I would take release 4, 5, 6, and 7 together. Release 4, 5, 6, and 7 are ancillary claims in this suit, while release 1, 2, and 3 are the main claims. It is right that when a claimant is denied of his or her release in the main, then any incidental release are ipso facto to be denied too. It is well established that you cannot put something on nothing. See the case of Fafunwa and Bellevue Travels Limited, citation is provided. The case of Nsugbe and Nkobi, citation is provided. The main claims having failed, the claims on damages, payment of salary and other entitlements, and post-judgment interest, which are ancillary to the main, must equally fail. I so hold. And for the avoidance of doubt and for the reasons earlier given in this judgment, I find that the claim of the claimant fails in its entirety. The claimant case is hereby dismissed. Judgment is accordingly entered. I award no cost.
My Lord, we must thank your Lordship for the well-considered judgment, which touched on all the issues raised. Actually, at the stage, my Lord, we were at a loss as to where the pendulum will tilt. But my Lord, we must commend you for a very well-considered judgment. May God continue to protect you in upholding the truth and to elevate you. We're grateful, my Lord.
Thank you.
My Lord, we are so very grateful for the judgment well delivered. We are grateful, my Lord.
Very well. So you may obtain copies as from tomorrow. Copies will be ready at the court. You can send anyone to pick up copies for you.
Most grateful, most grateful.
Very well. So you may excuse the court. The second matter, kindly give me just about 2 minutes to just drink water, and then we'll continue with the second case.
We'll wait, my Lord. Wait for your Lordship.
Okay, that's okay. That's fine.
Yes, my Lord.
Yeah.
Don't speak of your video is stopped. Come on. Ada biar akan loda. Kes mana mudi? Ko baba ke nan ba. Nine. Okay. First judgment.